just concerned about your own estate going through probate and what that might entail for family members dealing with it, or a friend you may have named as a personal representative. Probate is one of the probably most commonly misunderstood parts of estate planning, I would say, along with kind of what a will does or what a trust does. It's people sometimes ask me, well, what even is probate? Can you give me a background on what that even is, or what does that actually mean? I've heard things about it. And so that's a bit of what we're going to be talking about today, is some of, what actually is probate, what does it all entail? And so welcome everybody. I'm attorney Justin Randall with Hooper Law Office. If you are participating via Zoom, just to remind everybody, if this is your first time joining us, or if you've just needed a refresher on it, you can actually ask live questions through the Q&A function of Zoom. We have a couple materials, or really one main material coming to you if you signed up in advance in our, signed up by email and are participating via Zoom. It's our kind of handy cheat sheet of what goes through probate and what doesn't go through probate, and what happens if you are using a will as your plan, or you're intending for probate to be that sort of focal point of your plan, but don't have your assets go through probate. So it's a really good kind of graphic to help walk you through that. So one other thing before I get to in the weeds here. If you are participating via Zoom, you'll receive a feedback form at the end of this by email at some point today. And that just gives you a place to fill out a couple of things. One, if there's any topics you're interested in, you'd like us to talk about, or any feedback that you have. But it's also a place for you to fill out if you would like us to reach out to you to set up an initial consultation. Our initial consultations are complimentary. We don't charge you anything to come in and talk to us, because it's really important that we can sit down with you and really get to know you before we can give you a good recommendation on what we would, how we would design your estate plan. But they're usually set up for around 2 hours or so. They don't always take that long. Sometimes they take longer. It just depends on kind of the situation that we're going through with you, or what types of concerns you might have. So if anything I talk about today makes you think, oh man, I really want to go in and talk to somebody about this, that's a great place to let us know that you would like us to reach out and set aside time to talk with you guys. So so to get started, the biggest question that people have often about probate is, what even is probate? And probate is the court process in which your estate is divided up, in which creditors are paid, divided up amongst the beneficiaries that you've listed in your will. If you do not have a will, then the probate court, things going through the probate court are divided up by what in Wisconsin we would call the intestate succession, meaning basically it follows a set of statutes that say how your estate should be divided up amongst, mostly family members, spouse, children. It's kind of think of it as a will that the state of Wisconsin drafted for you, in which they sort of came up with the most common way that people divide up their estates. However, it's certainly not something you want to rely on as your primary plan, just because you want to be as intentional and as specific about where you want things to go as you possibly can be. The other part of it too is it gets way more complicated when you have second marriages or children from prior marriages that are not the biological children of both spouses. So it's just relying on the state statutes, and the default will in those statutes is certainly not ideal for most people, right? It's sort of there as an absolute worst case scenario. Somebody didn't do any planning. So probate is that process, though, in which the court will look at if somebody had a will, or if they didn't have a will, how to divide up those assets in accordance with that will, or lack thereof. And that is where one of the first big misconceptions about what a will does comes in for a lot of people, is thinking that, oh, I thought if I had a will, my assets would avoid probate. But really what a will is a list of instructions to the probate court of how you want your estate divided up, and who you want those assets to go to, how you want it to go to them, who you want in charge of handling your estate, all of those sorts of things. It's that is the only place that that will is going to have any sort of say on what happens. You couldn't walk into a bank, for example, or at least the bank shouldn't allow this. You could not walk into a bank with a will without having initiated a probate and say, divide the assets up this way. They would basically say, you have to show us that you are actually the personal representative with what's known as a domiciliary letter. So walking you through kind of what probate looks like for most people, probate is started after somebody's passed, when somebody submits the will or admits the will to probate. They submit it to the probate court, initiate the probate proceedings, and very often this person who is doing that is either a beneficiary or the personal representative. For those of you who are not familiar, I'm sure many of you are familiar with the term executor, the person handling the estate. In Wisconsin, that is just called the personal representative. It's the same thing. So me referring to it as that is just what you would hear it called here in Wisconsin. But it is the same thing as an executor. So if the person who submits the will to the probate court is the executor or personal representative, the court will, you have to notify all what they call the interested parties so that they can either approve or in any way object to the appointment of that person as the personal representative. Interested parties are generally a good way of thinking about this is, are they beneficiaries in the will? Or would they be beneficiaries of somebody's estate if this will were declared invalid or void for whatever reason? So those people all need to be given notice. And this can obviously be a concern more for people who are disinheriting people in particular, because those people may still be given, be required to receive notice, I should say, which obviously if they're being disinherited is maybe something that will cause them to potentially challenge the will if they so felt like it. It just certainly does not mean they would win that challenge. As long as the will was validly executed and the person had capacity and it wasn't, when they signed it, they were not subject to any undue influence. Just because somebody challenges that will does not mean they will win. Certainly not. But what I have seen in a lot of cases is if somebody wants to cause trouble, they will find a way to do so. Once that will is submitted and that person is actually approved as the personal representative, the court will issue what's called a domiciliary letter. Think of this as sort of that stamp of approval by the court that, yes, you can begin acting as a personal representative for somebody. And this is where if you needed to go to the bank or you had an estate account to pay for final expenses of the estate or any creditors of the estate, that domiciliary letter functions as that way of doing that proof that you are who you say you are and that you are approved by the court to act in that capacity. You can't just take, like I said, a copy of the will and say, see, look, I'm named here as the personal representative. That is not enough proof. That is not legally valid proof that you actually have been appointed as a personal representative. So, and it is really, when you put somebody down as a personal representative, it is really more of a nomination to the court. Then you're not guaranteeing that person will actually become personal representative. However, if there's not a really valid reason for them to reject that person, it's almost always approved. There would have to be a really good reason somebody objected with a very valid concern, like, hey, this person is, in a nursing home, they clearly can't act, maybe they've been diagnosed with Alzheimer's and they don't have legal capacity anymore. Something like that would have to be shown to the court to say, okay, that person is not fit to act as that personal representative, or if there was like fraud concerns or something like that. So after that person's been approved, though, that's when they can begin to pay off final expenses. And one of the reasons and one of the really important things that people need to be aware of with probate is that you are required to give notice to creditors. So the court sets the date on this, but it's usually around 3 months, 90 days. varying kind of a couple days here and there, depending on whatever date the court sets. But you have to give public notice to any unknown creditors. So that's usually something that's done through a newspaper publication of some kind, and you actually have to give direct notice to known creditors. So you can't just hope that if there was a known hospital bill, for example, you can't just put something in the newspaper and not tell that hospital in particular that, yes, we knew about you. We know that we owe you money through the estate. So that is a really good use for probate. Also for people who have what's known as a deficit estate. So deficit estate means you owe more money than you have when you pass away. And when that happens, the probate court can really act as a bankruptcy court in a lot of ways too, and make sure that the personal representative is able to deal with all of those creditors, make sure that they're paid what they can be. But if there's not enough to satisfy everybody, then they're absolving themselves of any fraudulent liability of trying to lie about what was in the estate. They're sort of getting that stamp of approval again by the court saying, okay, yep, you did what you had to do and what you could do. So this actually brings up a really good point though, with if you are using a will as your plan and you are intending for certain things to go through probate, making sure that the personal representative has some amount of liquidity in the actual probate estate to pay off expenses. As you will see, if you receive our little chart here, when certain things go outside of probate, and what would avoid probate for somebody who has a will is if they have direct beneficiaries on accounts, for example, or they are joint owners with somebody. Those types of designations or ways of owning something will avoid probate. But the problem that can be often created by this is if, for example, the personal representative is not somebody you intended to be a beneficiary, well, they then have no actual assets in the probate court to pay off any final expenses. They have to try to go to the beneficiaries to see if there's any way that they're willing to give them money back. And the problem with that is the beneficiaries of an account like that are under no obligation to share the expense or the burden with that personal representative. So you don't want to put the person you're naming in that personal representative role in a bad spot where they're going to even have to do that. So if you are intending to use a will as your plan, you want to make sure that at least some amount of cash assets are going through the probate process so that that person, as the personal representative, has access to those funds. A lot of times what we'll see as well is a personal representative is named as, is one of the kids, for example. And so they, on an account, all the accounts avoid probate, they're all left to the children equally. And they say, oh, you'll have money as the beneficiary to pay for those expenses. And that sounds great in theory, thinking, oh, all our kids will share those expenses, they'll all pay each other back. But again, they're under no obligation to pay that personal representative back. And if your intention was for the estate to be distributed equally amongst your beneficiaries, you don't want to put the one beneficiary who is acting as a personal representative in any sort of position where they have to not inherit equally now because they themselves were bearing the burden of those final expenses or creditor expenses that were ongoing. You just don't want to put someone in that position. The other issue that we see very commonly is the one asset somebody has going through probate is their real estate, more often than not, just somebody's primary residence. And none of the liquid cash assets or IRAs, which, certainly with IRAs, you don't want those to go through probate. There's no life insurance proceeds going through probate, not even somebody's checking account half the time. If there is a mortgage on the property or there is, ongoing property taxes that somebody has to pay, anything like that, well, again, if there's no liquid cash in the estate, that personal representative has no means in which they can actually pay those expenses, because the only asset, a good chunk of the time when somebody hasn't done proper planning is just real estate. So it's not liquid. And you just don't want to put someone in that position where they're trying to scramble to find ways to pay these expenses or possible, attorney's fees if they're, hiring somebody to help them with the probate. You don't want them to be personally, stuck in that situation. So if you are intending to use a will as your plan and are intending to use probate, you want to properly align your assets with that will and direct certain assets to go through probate so that your personal representative can actually deal with the expenses they need. So a little bit about kind of how long probate generally tends to take. And this goes to part of the reason why people think of it kind of as this boogeyman that you want to avoid probate, you want to absolutely never go through it. That's the common fear I hear from people. I'm not saying it's necessarily always a valid concern for everybody. But part of the reason people don't like the idea of probate is they've heard of how long it tends to take. The average time frame can range depending on the complexity of somebody's estate, how much, how many different accounts are going through, what the creditor situation looks like, if anybody objects to anything. I mean, obviously, any sort of disruption in the standard process is going to make it take longer. But even an average probate generally takes around a year to fully complete. And that's on the low end. It's usually a year to a year and a half. So it takes a long time. And that's why people generally would prefer to make it as straightforward as possible by leaving everything to family members via beneficiary designations. The issue with leaving everything via beneficiary designations, though, as I've mentioned, is one, allowing the personal representative to actually have access to those funds to pay expenses, but also it does not account for anything that could potentially go wrong in those beneficiaries' lives, like if they suddenly were disabled or had passed away or had substance abuse issues. So if you are using a will, you actually want the will to control those assets. But the length of time can be a big determining factor of why somebody generally is thinking they want to avoid it. I mentioned as well that there are some valid reasons to want to go through probate, and one of them I've talked about a little bit already is the fact that if you have a deficit estate, if you have more debt than equity in the estate than ownership, then you actually would want somebody to go through probate because it gives the estate a way to absolve those claims if there's not enough assets to pay for everything. And that way the personal representative can show that they've done what they need to do. And, they cannot come after, in Wisconsin, they cannot come after the children for that debt in that instance. So as long as they're not like co-signers on something, for example, if you co-signed on a loan as a child, then you're, on there as a co-signer and are obligated to pay it down as well. But you cannot inherit debt from your parents in Wisconsin. That's not true of every state, but in Wisconsin, you cannot inherit debt. So, deficit estate's a great reason. If you have minor children, probate is actually going to be necessary for at least part of the estate. And what I mean by that is where you name guardians for your children, your minor children, is you have to do that in a will. You can name temporary guardians for somebody, through like a financial power of attorney, so that while you're living, if you're incapacitated, you have a way to take care of, or somebody to take care of them. In permanent guardianship, though, somebody you're nominating after you're gone for your minor children, that has to be done through a will. So even if you had all of the money going through either a revocable trust and avoiding probate or via beneficiary designations, if you have minor children, where those guardians have to be named is in a will. So that is a very common reason that somebody would actually need to initiate some level of probate to make sure that those guardians are actually named and appointed by the court. Again, it's an important thing to remember that when you do name guardians on a will, that you simply naming them there and having it be a valid will does not automatically appoint those people as guardians. You have to first submit that will to the probate process after the individual has passed. If you're a married couple, obviously the surviving spouse has that parental right and is already there as that guardian. But if it's the second spouse to pass or both spouses pass together, that submitting the will to probate court is where they will look at who you've nominated as guardians. And then the reason it has to be approved by the court is obviously they want to make sure that the people that you've nominated there are fit. They don't want to put somebody in charge of a child who definitely shouldn't be, or somebody who maybe at the time was a perfectly valid choice, but has become incapacitated for some reason since. So you really want to make sure that they're the right fit at that time. So that's why the court has to actually approve them, and you are simply nominating them through the will. They weigh those nominations again, just like the personal representative. They give that a lot of weight. They give a lot of weight to the person's wishes on that. So just because somebody may not like the person you've named as guardian is not a reason for the court to deny them guardianship. They're not going to say, well, your sister who you've had a terrible relationship with says that this person is a terrible fit, so we're going to go with them. That's wouldn't fly. You have to actually have a valid reason why somebody is not fit as a guardian, like they would again have are likely to commit fraud or have some sort of mental incapacity where they can't act, things like that. So minor children, perfect reason to go through probate, at least some part of the estate. The third reason is actually there's kind of three and four, if you will, that are kind of interrelated. But the third reason is sometimes there are trusts that have to be created under a will, especially for spouses who are receiving long-term care. There's certain reasons in certain types of trusts that you have to set up through somebody's will. So if you have a trust set up by a will, in order to make that trust actually come into existence, you have to probate the will. It doesn't just automatically create it without there actually being that probate process going through that with the will. So there are reasons why, for certain Medicaid planning opportunities, you would want somebody's estate to actually go through probate. And then the fourth reason is, this is kind of a common sense one in some ways, but if you have any sort of inkling that people are going to no matter what, going to argue, going to fight, it's going to end up in court anyway, avoiding probate court is not actually helping you then, if by avoiding probate somehow the family ends up back in court anyway. So probate court can also be that place that people can come forward and challenge things, and you're already in a court then. So that's sort of a definitely not a reason to want to go through probate, but it shows you the benefit of probate for certain individuals in certain estates. So with that, with probate, kind of that process being outlined, another reason though that people tend to not really want to go through probate can be the cost associated with it. Probate tends to be more expensive in the long run than, for example, if somebody used like a revocable trust. In being completely upfront about that, part of that is attorney's fees. Attorney's fees tend to be higher in somebody's probate estate, or higher rates, higher hourly wages, whatever, or however that attorney is charging in a probate than potentially in administering somebody's trust. And part of that is it is a longer process, as I've mentioned. It tends to be more time on the attorney's part being actually involved in that process, and in more work on the attorney's side. So probate tends to be more expensive for people in the long run than using a revocable trust, for example. So the question becomes then, well, if you want to avoid probate, what do you actually, what type of plan should you use? And part of what I've, this little chart is going to show you is that, you can certainly avoid probate with different types of planning, but you want to make sure that you are accounting for things when you do so. A lot of times what I'll see is somebody comes in who wants to avoid probate and they have only beneficiary designations. Maybe they have a will, but now because all of their assets are avoiding probate by those beneficiary designations, that they are not actually using the terms of the will. So at that point, it's essentially a worthless piece of paper. So they have everything going by these beneficiary designations. Beneficiary designations, I'm not knocking on them as tools, because they are perfectly valid tools, and we use them a lot ourselves, but you want to use them correctly. It'd be like trying to hammer in a nail with a screw. If a screwdriver head, if you were using that as the actual main purpose of that tool. So you want to use the tools correctly. Um, Beneficiary designations do not account for certain things by themselves. What I mean by that is, I mentioned, a will, for example, going through probate with a will. Wills can have terms in there that say, well, if my child inherits from me, regardless of their age, if they have any sort of supplemental or special needs that they needed accounted for, or they're on any sort of means tested government benefits because of those special needs, or if they are on Medicaid when they inherit, because sometimes people's beneficiaries are the same age as them. And if you're dying of old age, well, your beneficiaries might, be in having their own care needs at that point. Or what if one of my beneficiaries has a substance abuse issue that I didn't foresee, because when I put them in the will, 30 years ago, they were a young kid, and now they're, 35 or so, and I know they have those issues. Wills can account for those things and say that if a beneficiary has those circumstances, they inherit in a way that would not cause them any harm, usually via some sort of, supplemental needs trust for a child with special needs, or making sure that they can't be in charge of the money, but can still receive the benefit of it. That's the sort of provisions you would have and want to have in somebody's will or in their trust, for example. But beneficiary designations don't account for those things, not when they pay out directly to that person. So if somebody named me as their direct beneficiary on an account, that would mean I get that money when they pass, directly in my own name. And if I have any sort of creditor issues that I, was dealing with at the time, or I was getting sued for some reason, or I was in the middle of a divorce, or, just a bankruptcy potentially, anything like that, or I was on some sort of means tested government benefit, that receiving that money would cause me trouble, because I would either immediately have to give it up to any sort of creditor issues that were going on, or if I was on a means tested government benefit, that would now count against me. I would have to report that, and that can kick somebody off of their benefits. So when you're using those beneficiary designations, you want to make sure that you're also accounting for those things, and those designations by themselves don't do that. You need to align them with provisions in a will or provisions in a trust in order to make those actually protected, via the terms of that will or trust. So there are certainly some things that you don't want to go through probate. Things like, for example, a qualified retirement account like an IRA or a 401k. Because of the fact that somebody's estate is not what they call a qualified designated beneficiary, or designated beneficiary rather, where that can force a 5-year payout, which as a pre-tax account, generally not something you want to force a 5-year payout when you would otherwise have a 10-year payout under the current rules. So if you are concerned about going through probate, you want to use the right plan for you. If you don't want your estate to go through probate, or you are concerned about what that looks like for your family members, there are better ways to avoid probate than only using beneficiary designations. And again, you can use beneficiary designations in conjunction with other planning, but by themselves with no other planning, that's where things can really go wrong if anything in a beneficiary's life is not going according to plan. But if you are somebody's personal representative and you are just, you're mostly here to learn about what do I need to do, that's where, coming in and talking with an attorney can be very helpful too, because sometimes things are very straightforward. Other times things are very, complex, or sometimes people are just grieving too, and they don't want to be responsible for all of that work. So that's where, when we deal with somebody's probate estate, we're doing a lot of the filing for our clients, and the only things that the personal representative really needs to do at that point is sometimes sign paperwork that we have prepared. So it can be very helpful for people to get assistance with this, because it's hard to know what you don't know, right? And this is there's only so much advice that a court is allowed to give somebody without them having their own legal representation, for example. I'm running quick on or short on time here, and I'm not seeing any questions, but just to let everyone know, our upcoming topic next week is actually estate planning things that you need to be aware of if you're a business owner, and how you incorporate business planning with your actual estate plan. And that's a personal favorite topic of mine, so I'm looking forward to that. But yeah, so if that interests anybody, please sign up for next week. And if you have any questions that you want to discuss with any of our attorneys, again, you can fill out that feedback form, or you can reach out to us directly and set up an appointment time to talk to one of our attorneys. Otherwise, if you have any other questions, you can always email learnmore@hooperlawoffice.com. But thank you all for your time today, and everyone stay inside and avoid all the rain that's going on.